Guyana found itself in a very strange position last week when the Caribbean Court of Justice ordered the country to pay some 6 million US dollars or 1.2 billion Guyana dollars to Suriname's beverage company, Rhodesia. The court ruled that Guyana would have imposed some wrongful tax on the company. This is as a result, of course, of Guyana's failure to pass a specific piece of legislation which was in Parliament before. I have with me in studio today the Honorable Attorney General and the Minister of Legal Affairs, Anil Nandlall, to give us some more details with regards to this particular matter. Minister, welcome to the program.
Thank you very much, Eddie, and good evening, viewers. Perhaps a convenient point to begin is to recognize that Guyana, as a member state of Caricom, has certain obligations to discharge under the Treaty of Chaguaramas, which established Caricom. Among those obligations is a duty on the part of each member state to remove from their legislative architecture all or any regime of discrimination which are levied on goods, beverages in particular, manufactured within the CARICOM region. In 1996, Guyana passed an environmental tax law and incorporated it into the Customs Act, by virtue of which a particular tax was levied on containers containing beverages which were produced outside of Guyana. That tax was not applied to local manufactured beverages, and therefore that tax in effect discriminated against goods produced in the region. At the time, of course, that obligation did not devolve upon Guyana. Subsequently, it became the subject of a treaty obligation. And it has been an issue that has faced us for a while. Guyana was essentially caught in a dilemma because on the one hand you had very strong representations being made to the government on behalf of the local manufacturers, and their arguments, if I may summarize them, essentially were that this tax is necessary to protect the local industry, and that if this tax is removed, the local industry would be unable to compete with the foreign manufactured goods, especially since the goods that were manufactured in different jurisdictions were done where the cost of electricity, for example, was far lower than the cost in Guyana, and that those countries provided a regime of indirect or disguised subsidy from which those manufacturers were benefiting. And on the other hand, we have these local manufacturers who contend that they have to operate at this comparative disadvantage, and they are contributing significantly more to the GDP of Guyana. They pay more tax than the foreign manufacturers. They operate locally, and therefore they employ hundreds, if not thousands, of Guyanese, both directly and indirectly. So they were compelling arguments which were advanced to the government, and the government tried as far as possible to maintain this protectionist regime in relation to local manufacturers. However, the position became progressively difficult to defend at different Caricom fora, especially at COTED, where it became part of the agenda and it remained there for a number of years. Significantly also in this entire equation, one cannot discount the establishment of the Caribbean Court of Justice. Prior to the establishment of the Caribbean Court of Justice, there was not really any forum to which one could have gone to claim enforcement of a treaty obligation or to prosecute an allegation of treaty violation. That lacuna in the legal architecture of the CARICOM region was filled with the establishment of the Caribbean Court of Justice, which has, apart from an appellate jurisdiction, an original jurisdiction to treat specifically with the interpretation of the treaty as well as the ventilation of disputes regarding treaty violations. So there were significant changes that were made that really made it impossible for Guyana to continue to provide this type of protection for the local industry. And then the matter came to A4 when the Rhodesia Company, Beverage Company of Suriname, filed a legal challenge against Guyana, claiming that the regime of taxation about which I am speaking violated essentially the revised Treaty of Chaguaramas. What is significant, however, is that while the case was pending, the Rhodesia Beverages Company indicated that they were prepared to withdraw their claim fully and absolutely if the Guyana Parliament was to pass a bill to remove that discriminatory tax. And of course, I asked the court then for an adjournment to lay a bill to that effect in Parliament. Of course, by that time, government was already advised that a change of law is necessary. The bill was quickly prepared and laid in the National Assembly, and the case was adjourned to facilitate the enactment of this bill. Lo and behold, first of all, the bill was the opposition in particular requested several postponement of second reading of the bill on the ground that they were discussing with local manufacturers. Eventually, the bill was debated a second time and was voted down by the opposition.
But if I to interject here, Minister, when this bill was debated, was it made clear that this particular piece of legislation, this amendment, was necessary in face of ongoing court proceedings and in face of the statements by Rhodesia that okay, we're willing to drop the case if the government of Guyana would have rectified the issue?
I spoke at length on this bill, and in my presentation, I detailed the fact that we have treaty obligations under the revised Treaty of Chaguaramas from which we cannot shirk as a member state of CARICOM, that there was a pending case at the Caribbean Court of Justice in which Guyana was sued specifically because of the violation of those treaty obligations, and that the court was adjourned specifically for the enactment of this bill. So I will answer your question by saying that I detailed in a very emphatic way and presumably in very clear and specific language, what was at stake. So the entire Parliament was fully apprised of all the facts and circumstances attendant to the issue at the time.
So in essence, you're saying Guyana is more or less responsible for this, having to pay this $6 million to Rhodesia.
Let me say that the opposition, members who spoke on this bill, and I distinctly recall presentations being made by Mr. Carl Greenidge and of the APNU and Mr. Kemraj Ramjatan. And if I recall, I distinctly remember Mr. Carl Greenidge's argument was that we are not in violation of the Treaty of Chaguaramas, that I completely misunderstand what those obligations are, and that the bill is completely unnecessary. That, in essence, was what Mr. Greenidge's arguments were. Secondly, Mr. Ramjatan's argument, as far as I recall, he very candidly said to go back and tell the Caribbean Court of Justice that the Caricom and the CCJ do not run the Parliament of Guyana, that the opposition are in control of the Parliament of Guyana. This was an attorney at law speaking, and a person who wants to be the president of this country. That, in essence, is what I recall his presentation to be. Now, to answer your question whether Guyana called this disaster upon itself, I will say that the legislature of the country largely is responsible for the precarious position that we are now in because of their callous rejection of this bill. Now, importantly, the CCJ did not award damages, and we are fortunate that they have not awarded damages. They have simply ordered us to reimburse the taxes that we would have wrongfully collected from this company. That, in essence, is the judgment. And what the CCJ said, which is of tremendous importance, is that in terms of treaty obligations, in terms of international obligations, the state of Guyana is not divisible. And therefore, it doesn't matter one moment that the government, executive government, is displaying a willingness to discharge its obligations, but the legislature is completely disregarding its obligations or those obligations. For the purpose of international obligations, the state of Guyana cannot be divided into executive government and legislative government. That Guyana is a unitary whole as a nation state, and that unitary whole shall be held responsible for whatever violations Guyana commits, whichever arm of the state may be specifically responsible or culpable for those violations.
So in essence, one cannot use the argument, oh, it was the government who failed to do it, or it was the parliament who failed to do it.
We can
but
use,
it's Guyana that essentially fails.
And
I think
yeah,
that's in essence.
Guyana failed because of the negligence and recklessness and irresponsibility of the opposition in the National Assembly.
But
what is significant and what the people of Guyana must understand is that this is $6 million which could have been used to purchase medicine for our children, health supplies for hospitals, computers and equipment for the labs of the schools of our country. It could have been purchased, it could have been used to build more roads in our country. It could have been used to increase pensions. It could have been used to subsidize electricity for more people of this country. Instead, this money has to now be paid to a foreign company that will continue to do business in Guyana and continue to make profit. So at the end of the day, the people who are ultimately going to suffer from this tragedy are the people of Guyana, and the opposition must accept responsibility for that.
But how do we treat with we haven't amended the law. It's still there. The company is still operating. How do we treat with the company? And on one hand, the law is saying that you have to charge this tax, and on the other hand, the company would have, the CCJ would have ruled against us charging it. How do we treat with it in the future? Are we going back to Parliament with the bill?
We are in that conundrum presently, and the eminently sensible procedure to adopt in the circumstances, in my humble view, is to simply go back to the Parliament and retable the bill. And if one is to only go by the arguments which were advanced, and to which I made reference earlier, Mr. Greenidge was contending that it is not a treaty obligation. Obviously, the Caribbean Court of Justice has proven him overwhelmingly wrong, and so there is no argument anymore from APNU that can make sense. Not that that one made sense. And then secondly, Mr. Ramjatan, I don't think, can have the luxury of irresponsibly making pronouncements that the CCJ must be told that Caricom and the CCJ do not run the Guyana Parliament. I mean, I think that is a most infantile statement for a responsible politician to make. So, and we have a judgment in writing that essentially says to us in unambiguous and unequivocal language that the tax is contrary to our treaty obligations, and therefore we need to rid it from our tax, we need to rid that measure from our legislative architecture. And we can only do that by retabling the bill in the Parliament. So that is the course that I believe the government shall soon adopt.
Minister, I want to take you over to another topical issue, a very, very important and critical issue for Guyana, and more so Caricom. And this has to do with the amendments to the Anti-Money Laundering and Countering the Financing of Terrorism bill. The Caribbean Financial Action Task Force is due to start its May review on the 26th of this month. That's later this week. And of course, Guyana again is going to come up for a review. We are still to move to get anywhere, as a matter of fact, with our anti-money laundering amendments. Could you say what is the current state of play at the level of the Special Select Committee where this bill is?
There is indeed a deep connection between the topic that we just addressed and our obligations under CFATF and FATF. Recall the Caribbean Court of Justice making it excruciatingly plain that for the purpose of the discharge of our international and treaty obligations, the state of Guyana is not divisible. We have that principle again would be applicable to the situation at hand, because again we are confronted with a situation where the opposition in the National Assembly is deliberately frustrating the government from discharging Guyana's international obligations. On that, in relation to the Caribbean Court of Justice matter, the people of Guyana would have seen that they now have to pay 1.2 billion Guyana dollars to a foreign company. It is the people who have to pay that, not the government. The government gets the money from the taxes that are paid by the people. So the people have to pay that money as a result of the opposition's actions in the National Assembly. Here again, you have the people of Guyana who are going to, by and large, be the victims of all the sanctions that will flow. Now, where are we in relation to the AMLCFT? You would have read in the newspapers that the select committee that has custody of this amendment bill has not been able to meet over the last 2 weeks. I saw in the press that the chairperson has issued statements to that effect. The opposition members have manufactured one reason after another for their unavailability to meet, and as a result, we have not had a meeting over the last 2 weeks. Now, there have been some significant developments in this interregnum. Recall that the the CFATF chairperson, Ms. Allyson Maynard-Gibson, the Honorable Attorney General of the Bahamas, along with the Executive Director of Caricom, visited Guyana. The Executive Director of CFATF, visited Guyana and met with both the government and the leader of the opposition, and I believe they met with certain important stakeholders. At that meeting, those two persons would have outlined to the government and presumably to the opposition as well, the importance of passing the amendments, and rather the importance of passing a CFATF compliant bill. And what are the consequences that will flow if we are not compliant, if we don't pass the bill? And they detail the draconian consequences that will be unleashed on the Guyanese people if we are unable to pass the bill. They spoke, for example, of the fact that the Guyanese economy and Guyana as a country will be economically and financially estranged from over 190 countries worldwide who are members of the Financial Action Task Force. Because the Financial Action Task Force will issue a statement inviting all its members to impose whatever sanctions they deem fit on Guyana and to take such steps necessary to protect their financial architecture from the contamination that will flow from Guyana if Guyana is declared to be non-compliant and deficient in its AML-CFT regime. All these arguments were put out in a very elaborate way. And significantly, the chairperson of the Caribbean Financial Action Task Force said to us in the government, invited us to send up to the Caribbean Financial Action Task Force technical personnel a copy of both the government's draft and the opposition's draft. Well, the government's draft has already been approved. So we sent a copy of the opposition's draft because they asked us to send a copy of that draft so that the technical personnel of the Caribbean Financial Action Task Force can examine it to see whether it is compliant. Recall that we are not legislating at large here. We are legislating with a specific agenda of incorporating recommendations which have been made to us by CFATF when they did the second round of evaluation.
So have we sent the copies to them?
I'm getting to that. But I want to make these points that we are not legislating at large. We are legislating within certain parameters, and those parameters were dictated to us by the Caribbean Financial Action Task Force in their report when they assessed Guyana in its second round of evaluation. So we are to be confined to those recommendations. So yes, to answer your question, we sent a letter. We sent a covering letter along with the opposition's draft to the CFATF. And as I predicted, the CFATF rejected every single one of the amendments that they are proposing. You could recall that they proposed that they would like to see a deletion completely of the role of the Attorney General from the whole process. The CFATF answer to that provision, that suggestion, was that it is wrong. The Attorney General is put there because he or she is the legal advisor to the government and would be the recipient of all legal materials that will come into the government's possession in relation to its relations with organizations such as the United Nations Security Council and other international organizations. And it is the Attorney General that will have to go to court for and on behalf of the government to seek certain orders to give effect to the government's obligations under various treaties. And therefore, the office of the Attorney General is important in the legislative apparatus of the CFATF, the AMLCFT regime. So that was the first point they made. The second point had to do with Parliament appointing a whole authority to oversee and supervise the FIU, the Financial Intelligence Unit, its operations, and its officers. As we said, that type of regime, that type of mechanism will undermine the functional autonomy of the FIU, which by all international standards must be functionally independent and autonomous in the discharge of its day-to-day functions. And it must be free and insulated from political interference and influence, both apparent and real. The CFATF advice on that particular proposal of the opposition was that it does not meet the international standard, that the mechanism for appointment is politically contaminated, and that the method or the mechanism that it creates removes from the FIU and its staff and directors that important requisite financial autonomy and functional independence. And they rejected that as well. And of course, none of these are recommendations which have been financed for us. And the third condemnation in relation to what was submitted of the opposition's draft related to the seizure of money. Recall that they have that seizure of money, seizure of cash, and cash has that expansive definition about which I have spoken so many times. They also deprecated and rejected that on the ground that that is not part of their requirements and that it's completely unnecessary to impose that on the regime of the AMLCFT. And significantly, they pointed us to the several jurisdictions in the Caribbean that they are oversighting, and they said to simply use the mechanisms that have already been used in the Caribbean, because you see they are overseeing and supervising certain established models, and these interventions which have been made by the opposition in the form of legislative amendments or proposals of legislative amendments cannot be found anywhere in the world. There are models that have been created by the experts, and that is what you have to promulgate as part of your regime. So the CFATF essentially has rejected the opposition's amendments.
Minister, we have to wrap this up, but quickly in just about a minute or so, if you could tell us, Parliament meets on Wednesday, and I think that is the final opportunity before Guyana is reviewed. You're saying that the Special Select Committee is not meeting. Um,
Well, I know that there are desperate efforts being made by the chairperson, even as I speak, to have a meeting before the next sitting of the National Assembly. Guyana is required to have this bill passed on or before the 26th day of May. Um, the
if that doesn't
opposition,
happen,
the opposition seems unconcerned. In fact, they are doing everything, in my view, to prevent that from happening. You know, all these amendments that they have proposed are in relation to the Principal Act. The Principal Act which they passed unanimously in the ninth Parliament. They sat and they passed all those provisions unanimously. Now they have some epiphany and they want now to change all these things, which are not recommendations of the Caribbean Financial Action Task Force. So it would appear at this point in time that it is unlikely that the bill will be passed, and what I presume or what I predict will transpire at the CFATF meeting on the 26th to the 29th of May is that simply a decision will be made to give effect to the decision which has already been made at the November plenary, which is that Guyana shall be recommended to CFATF, Guyana shall be recommended to the Financial Action Task Force in Paris, France, for a review, an ICRG review to begin of Guyana. And that, in essence, is the blacklisting that we are speaking about.
Minister, I want to thank you very much for joining me today. We discussed two issues. One, Guyana having to pay to Rhodesia, Suriname, $6 million or 1.2 billion Guyana dollars, and of course, another CFATF deadline is staring us in the face, the 26th of May, just a few days from now, for us to pass the Anti-Money Laundering and Countering the Financing of Terrorism Amendment Bill. The Special Select Committee is not meeting. Parliament meets on Wednesday, and it seems highly impossible that we'll be able to pass that bill. So, unless there is a meeting and there is passage of the bill, Guyana is likely to face some blacklisting from FATF. Again, Minister, thank you very much, and thank you very much for joining us.